Hello friends, today's my topic is about Money Lenders Act. Money Lenders Act and how the money lender has to take license to operate money lending. And if he does not obtain any license, he lends money for on interest basis. Whether he can claim before the court whatever amount he has given on as a loan or the amount he has led to the peoples. As per the Act, Money Lending Act, the Act says one who gives money on basing on interest to somebody, he has to obtain money lending license, and the license which he has to obtain is from the appropriate authority. And if a person without money lending license and he operates the business of money lending, then he cannot claim the money which is led before the court. There are several judgments on this issue that money lender not possessing the license on the date of transaction, suit filed by him for recovery of the amount not maintainable. This is section 2 clause 4, section 2 clause 7 and clause 3. Money lent without interest does not fall within the ambit of the definition loan. When once a transaction not a loan within the definition, it amount to wholly unnecessary consider the question whether the plaintiff is a money lender or not, because money lender under section 27 Act is defined to mean a person including a pawnbroker who within the meaning of this act only advances person including a pawnbroker. So the Money Lending Act says one who possesses the license, then only he can claim before the court and he can file a suit for recovery of that particular amount. If a person operates money lending without obtaining any license from the appropriate authority, then the suit which he will file before the court will be dismissed by the court. Basing on that, the money lender should, unless and until he obtains the license, he cannot run money lending. So that is the factual position before the judiciary. A person advancing money casually does not fall under the definition of money lending. If a person gives hand loans or something without mentioning any percentage of on that particular amount, then it does not come under money lending. Money lending is specially a note has to be executed or he has to take money basing on interest. If a person lends a money to someone without mentioning about the interest or anything, that does not come under money lending. So money lending is nothing but giving an amount on loan with a specific interest, then it will come under Money Lending Act. And if a person lends his money to different people on interest basis, he has to at any cost obtain license from the appropriate authority. That is a factual position of the judiciary or the act says. Suit transaction substance was lending money to the borrowers by taking sale deeds agreement for recovery and obtaining rental deeds so as to avoid the application of Hyderabad Money Lending Act. Such transaction was held amounting to loan within the meaning of section 2(4) of the Act. Judgment Haseen Babu versus Syed Habib Saiduddin and others, 1996 4 ALD 236 DV, Division Bench. So, when a person lends money and the borrower pays certain interest to that amount for taking amount, then it is compulsory that the person who is lending the money or giving money, he should have the license. As per section 3, the clause 1, every officer who has been authorized by the government under this act shall maintain a register of money lenders in such form and with such particular as may be prescribed. So the government will authorize a person to get the information with regard to persons who are having registration about the money lending. The detailed information should be there with the government. And this clause 2 says every money lender in order to get his name registered shall present the application in writing and prescribed form before the appropriate authority. And the fees which will be collected by the government is 25 rupees fixed for a district concern. And no money lender shall carry on in any district the business of money lending without obtaining license provided for in subsection 2. This is clause 5 of section 3 of Money Lending Act. So it is very much clear that a person who is lending money to different people or basing on interest, he has to clearly get registered his money lending business. And further, any money lender referred in subsection 1 who carries on the business of money lending and provision of the said subsection or recovers his dues otherwise then in accordance with this provision of subsection 3 shall on conviction before the collector be punished with imprisonment for a term which may extend to 1 year or fine with both. So this is the conviction that will be given in case where a person is operating money lending without obtaining any license. So the main provision says that one who operates money lending, he has to get registered his money lending business. And in the section 9 says procedure of court in suits for recovery of loans. Clause 2 says if it is proved that the plaintiff is a money lender as defined in subsection 7 of section 2 but does not hold a license granted under section 3, the court shall dismiss his suit. So if a person does not obtain any license and he operates money lending and borrowers to collect from borrowers any claim, if he approaches court under this particular section, the petition suit will be dismissed by the concerned authorities or our court. And interest, what is the interest that has to be fixed by the money lender who has obtained the license from the government? It is the government may from time to time by notification in Andhra Pradesh Gazette fix the maximum rate of interest for any local area or class of business money lender in respect of secured loans and unsecured loans. So there are two variety of loans, that is secured and unsecured loans. So interest will be the interest which has to be fixed is the government under section 10. Government may fix as per Andhra Pradesh Gazette notification the amount which has to be collected by the money lender with regard to the money he will lend to the borrowers. And in other words, money lender cannot claim debt or liability from others from his debtors without valid money lending license. And another clause says whoever being a money lender demands or charges or receives from the debtor interest at a rate exceeding the maximum rate fixed by the government under clause 1 shall punish with imprisonment for term which may extend to 6 months. So a person who is money lending and having license, he has to at any cost comply the law which is prevailing in particular state. If he exceeds from the direction of the act, then he will be punished under for 6 months. This is the provision of law. And with regard to interest rate, the money lender agreement money lender may charge simple interest on such sum by way of damage from the date of default until is paid at the rate not exceeding half of the rate of interest payable. If a person borrows money and he will be defaulted by paying amount and installments, the installment amount with interest, if they want to collect, they have to collect half of the interest rate on the defaulted money and all. They cannot charge about that. That is clause 2 of section 10 says about this. So this is the provision of money lending act which says how the money lenders are supposed to run their business, what provision of law they have to look after, and how they will be punished if they will go against the provision of law. And moreover, even the power of court to limit interest due in certain cases, even court can limit the due amount, interest amount, as per the provision of law. Section 11 says separate accounts of the principal and interest shall be maintained by the money lender. This is one of the clause. And clause E says, section 11, a calculated principal shall be calculated at the rate agreed between the parties provided that it does not exceed 9% per annum. And in case of secured loans, that is with regard to loans, regular simple interest, and with regard to secured amount, case of secured loan, 12% shall be per annum interest that has to be calculated by the money lender. And as per the section 12, order for payment decretal amount by the installment, If a person files who is having money lending license, he files a suit for recovery against the debtor, the, so he can file it. But as per section 12, the court can order for installments the amount which has to be paid by the borrower. The court can decree saying installments can be paid by the borrower. That is section 12 of the money lending act says. And as per section 13, punishment for molestation of debtors. Sometimes the money lenders, they will appoint people to collect their amounts. If those people will misbehave with the borrowers, they will be punished under section 13. Obstructing the debtor or uses violence against or intimidates him, follow the debtor wherever he goes, or interferes with any property owned or used by him, or deprives him of or hinders him in the use of thereof, he will be punished as per the section 13. So money lender, when he is engaging people to collect money, they should not behave like this, like obstructing the debtors and creating nuisance and interfering with their personal properties, or they cannot enter into their property without the permission of court. They cannot manhandle or misbehave with the borrowers unless they have to go through proper channel, that is filing a suit before the court, and the court will fix the amount which has to be paid and the interest that has to be paid on the amount. That is the provision of law. The state government may make rules for the carrying out the purpose of this act shall come into force on the date of a publication. So, employment debt collectors. If a money lender appoints some persons to collect the amount, if he appoints people, that diary has to be maintained by him under section 11 of money lending regulation 1960. Every person employed by the money lender to collect the arrears of amount or installment by his employees, he has to get registers his name with regard to employment debt collector under section 11 of money lenders regulation act. So the money lender cannot appoint anyone without the information to the government whom he is appointing under section 11 of money lending regulation act. No person shall be employed by any money lender for the purpose of demanding or recovering any loan due to him unless such person is in possession of a certificate authorizing him to act as debt collector granted under this section. Clause 2 says every application for such a certificate shall be made to such authority and shall be in such form and shall contain such particulars as may be prescribed. And before certificate is granted to him, the applicant shall satisfy such authority that he bears a good character. So this is this in position of law, which says money lender should obtain license from the concerned authority, and he should not take excess of interest amount as prescribed by the government. And if you want to collect any amount, if he going to file any suit for recovery, he should be a license holder, then only court will entertain his suit or petitions. And if you want to appoint anyone on behalf of him as an agent to collect the recover amounts and everything from the borrowers, he has to file application or information to the concerned authority. They cannot be operative under this law, or they will be punished as per section 13 of money lending act. Thank you very much, friend, for watching my video. Namaskar.